Hello, everybody. My name is TJ Scott, or Timothy Scott, and I am the owner of the law office of Timothy J. Scott. I'm an estate planning attorney, and what that really means is I help people get their affairs in order so that when they're gone, their families are taken care of and their families don't have to fall into court and conflict. And I've got to tell you, I am so happy to be here with you on this sweltering Minnesota day. I'm glad that you're inside. I hope that you have air conditioning. Maybe you're not inside. Maybe you're out on a porch or patio somewhere enjoying this webinar. Wherever you're joining me from, I'm really happy that you're here with me today. In fact, if you can find the chat box, if you can let me know what city or state you're joining me from, I would really appreciate it. It'd be really fun to get to see where people are calling in from or where people are joining the webinar from. We're going to talk about something today that is really difficult, and I know it's difficult. We're going to be talking about incapacity. We're going to be talking about death. And like I say, I know that is a really difficult thing to talk about and to get through. But I also believe that knowledge is power, and that's what I'm here to do today. I want to educate you and I want to empower you so that you can have some peace of mind around incapacity and around death. We all know that it's going to happen someday, and it's hard to make peace with that, but we can have a sense of peace when we get things arranged for our families in a way that we know they're going to be well taken care of in the best way that we can take care of them during our lifetime. So today I have some really valuable information that I want to share with you and some valuable offers that I'm going to have here at the end of the presentation. But before we start, I just want to say you have reserved this time here today to be with me. And I really encourage you to be present with me and to focus on spending this time learning the information that we're going to be talking about here today. So please turn off distractions. If you have another window open in Chrome or whatever it is, I encourage you to set it aside. It'll still be there after this webinar, and just give yourself this time to learn and give yourself this time to educate yourself. And I always say this, I always say your future self will be glad that you took the time to learn. And it's really true that your future self will look back and say, you know what? I'm glad I spent that time with TJ Scott on a Wednesday night, and I feel a little bit more comfortable. I feel like I know more about this topic than I did before. I also have to say, I see people joining us from North Carolina. I see people joining us from St. Louis Park, Lakeville, Minnesota. Welcome, everybody. I'm so happy to have you here with me today, and I hope that you'll, again, bring your questions and bring your energy to our meeting tonight, or to our webinar tonight, so that we can make it really productive for everybody. So as a bonus, if you stick around until the end today, I'm going to tell you how you can get a free one-on-one meeting with me where we can talk about the things that you're going to learn about here today. We can talk about how you can protect the people that you love, and you can protect your assets and make sure that you really steward those in the best way possible to the people that you love. As a bonus, I'm going to give you a gift that's going to make it even easier to get a custom tailored estate plan written for you that, again, is going to take care of the people that you love. But first, I'd like to ask some questions. And the first question that I have is, do you have an estate plan? So I'm going to pop up a poll here, and you should see a poll that says yes or no. You should be able to make a selection. I see somebody has already responded no. I'm seeing a lot of no's tonight, actually. What you see on the screen here: trust, will, guardianship, nomination, healthcare directive, power of attorney, beneficiary designations. These are all really parts of an estate plan. So I have a lot of people who come to me and I ask them, have you done an estate plan? And they say, oh yeah, I've got a will. And the truth is that an estate plan is different. An estate plan is an all-encompassing plan that deals with all of your assets and makes sure that they're going to get the treatment that you want those assets to get. So just be aware that you may have beneficiary designations on retirement policies, on life insurance policies. You may have a will that's written. Maybe that will was written 10 years ago or 15 years ago, and maybe you're not even sure exactly what that will says. All of these things are part of an estate plan, and they're all things that I help with and that I work with my clients on. I'm definitely seeing a lot more no's right now than yeses. And you know what? I understand. There are, let me post this up here. Another poll asking the question, if you don't have an estate plan in place right now, why not? And the truth is that about 69% of Americans don't have an estate plan in place. And there are lots of reasons for it. And I really understand those reasons. Some people feel like they're too busy. And trust me, as a father of three, I totally get that. Life is really busy today. But if that's the case, again, I just want to commend you on being here tonight and giving yourself this time to be with me and learn and start to explore what it would take to get an estate plan in place. I'm seeing a lot of people say too expensive. And again, I totally get it. We're going to talk about exactly what you should expect to spend on an estate plan this evening. We're going to talk about what you can expect to spend from a typical traditional estate planning attorney that isn't really probably going to cover your needs. We'll even talk about what you can expect to spend on something like an online will, which frankly definitely isn't going to take care of you and take care of your family in the way that you would want it to. But we'll talk about those things. And I'd also like to just point out that before the invention of word processing, estate planning was only for the wealthy. It's true. Estate planning used to have to be these documents that were filled out in triplicate. And if you made a single little error in that document that was filled out in triplicate, you had to start all over again and waste that carbon copy paper that was expensive and start fresh and take all of that time to recreate that document from scratch. But today we have word processors, and estate planning is more accessible than it has ever been. And estate planning really is something for everybody. It's something for the upper class, certainly, but the middle class, everybody can afford to get a great estate plan in place and to really take care of the people that they love in a really superior way these days. I'm not seeing anybody saying that they're too young. And I don't know why that is. I guess we've all survived 2020. Maybe none of us feel young anymore. We've all got a little, we're all a little jaded from what we used to be in 2019. But the truth is that anyone over the age of 18 should really have an estate plan in place. And I was recently helping a young family where a young father had passed away and unfortunately left kind of a mess behind for his wife and minor daughters. But that really doesn't have to be the case. I've helped young people, especially young families, get their affairs in order. And I've seen the relief on their faces from having that plan in place and knowing that their kids are going to be well taken care of. Their kids are going to be with the people that they want them to be with. And it really lifts a burden from their shoulders. One thing I'm not seeing is anybody saying that they're worried about jinxing themselves, but I've seen this before and I've heard it a lot before. And I just want to make sure that you're rest assured that I have done a lot of estate plans for a lot of people. And I have never seen a correlation between somebody having an estate plan done and having something negative happen to them or to their family. It just doesn't happen. There's not a correlation like that. So don't worry about jinxing yourself. Again, I'm not seeing anybody saying that they are, but sometimes we hold that a little bit deeper than we're willing to admit. I have here a question. If you are a beneficiary of a will, how can you obtain a copy of that will? And that's a really good question. One thing that we're going to talk about is the fact that wills are public and they need to be filed with the probate court. So you should be able to go down to the probate court and receive a copy of that will if you know the case number of the probate. You should also be able to receive a copy of that will from the personal representative. Sometimes personal representatives don't do the perfect thing. They don't hand over the will like they're supposed to, and they're not as clear on information as they're supposed to. We'll talk about that in a little bit. Again, some kind of negative things about probate and the probate process. But just so that you know, you should be able to obtain a copy of that will in that way. All right. So if you have an estate plan in place, what do you want to learn tonight? And even if you don't have an estate plan in place, is there something on this list that's jumping out to you? Maybe you want to know if an online will is okay and if it's going to take care of your family. I've already kind of alluded to the fact that it leaves a lot of people underserved. It leaves a lot of families underserved from what a full estate plan can really take care of for that family. Maybe you completed a plan in the past but you're wondering if it's outdated. Maybe you named guardianship nominations in that will or in that estate plan, and now you don't have minor kids anymore. You haven't had minor kids for years. Maybe your grandkids aren't even minor kids anymore. I don't know. But you want to know, is my plan outdated? Is it still going to serve me? Is it still going to serve my family in the way that I want it to? And maybe you just want to have a better understanding of this entire estate planning area, or a better understanding of your plan. Maybe the attorney that you worked with wrote you a plan, sure, but they didn't really explain things. They didn't empower you, really educate you to know what was in your estate plan. And again, I've said this a number of times, but I know that we've had people join us as well. If you have a specific question that you want answered today, I hope that you will pop it either in the chat or in the Q&A, where you can ask questions, and we can get really clear on that. So I see a lot of people saying, I want to better understand my plan, and that's fantastic. I'm really glad that you're here tonight. I am definitely going to speak to that. I'm definitely going to speak to the full gamut of estate planning and what different things mean. I see a few people saying, is my plan outdated? I see somebody asking, is an online will okay? And I'll definitely speak to that. I also see a question coming in. I have no idea how to do one. How do I even start to get an estate plan into place? And we will talk about that tonight. And we'll talk about what exactly that looks like. We'll talk about what the process actually looks like, and how you can get it done, and how you can get a great estate plan in place for your family. But I want you to know that whatever the reason that you're here today, you are in the right place. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online will or a fill in the blank will, one of those, carbon copy, fill in the blank type of wills. I haven't seen one in a little while, but I have seen them before. And you're wondering, is it going to work? Is it going to take care of my family? And you're also in the right place if you're nervous about how much this is going to cost. And again, that's something that I'm going to talk about in detail a little bit later on, and that I want to give you some peace about. A couple other questions that I'm seeing coming in. I'd like to learn about considerations for beneficiaries who reside outside the US and are not residents. And that's a really fantastic question. It's a question I'm not probably going to answer in a lot of detail tonight, but I hope whoever has that question will feel comfortable reaching out to me, and we can have a conversation about that and how you can make sure that that money gets to the person you want to receive it. I see another question here. How do you complete an estate plan in a way that doesn't create tax penalties for beneficiaries? And this is huge right now. Some people know there was an act that was signed into law under President Trump called the Secure Act. And at the time, it seemed momentous. It seemed like it was going to change a lot of things, and it did change a lot of things, but it was kind of overshadowed by everything that was happening in 2019, 2020. And so it is really important to know that there are some ways that you can save your beneficiaries from having to pay a lot of tax. This is also something that's coming up a lot more right now with some proposals that are coming out of the current administration. There's some proposals to have a different treatment of capital gains. There are some proposals to have a different treatment of something called step up in basis. And there's some proposals to seriously reduce the federal estate tax exemption. The federal estate tax exemption probably still won't hit a lot of people who are in attendance here tonight. It doesn't hit a lot of people except some very high net worth people, but still, it is something that a lot of people have on their minds and they need some reassurance about. Again, this is something that I will talk about in some detail tonight, but if you have concerns about it, I hope that you'll reach out to me and we can really talk about it in great depth in the context of your specific experience. I have another question here. Can the executor of a will screw the beneficiaries over? Excuse my language. Who is watching over the executor to make sure he is acting in the best interest of the beneficiaries? That's a fantastic question. It is a really scary experience to be a beneficiary in a probate where you're not sure that the personal representative has your best interests in mind, or the executor has your best interests in mind. The court is watching. the personal representative has a fiduciary responsibility to make sure that they are doing things for the benefit of the estate and that they're doing things for the benefit of the beneficiaries or the heirs. So you can rest a little bit assured that there is probably some court oversight if you have concerns. If there's a lack of transparency, if you have concerns about the way that things are being done, then reach out to an estate planning attorney, reach out to somebody who does probate and probate litigation, and they can get involved in the process and make sure that there's additional transparency, that things are being handled in the way that they're supposed to be handled. Really good question. Another question, are estate plans needed for a single person? And again, this is a great question. It's difficult to speak to need because everybody's needs are different, and what everybody feels is a need is really different person to person. And so I can tell you in my one-to-one meetings with people, we talk through a number of different things that the state's plan, because really, if you don't have an estate plan in place, the state has provided one for you. And so we talk about what is the state's plan for you? And what is the state's plan for your family? And what's the state's plan for your assets? And what's the state's plan if one of those assets isn't found by the personal representative or by somebody who's trying to collect all of your assets and make sure that they go to the people that you want them to go to? And if those types of questions bother you, if there are things that we talk about tonight that bother you as a single person, then you would probably benefit from having an estate plan written. And that's really the key is how much do these things bother you? How much does probate bother you? How much does, if you're a single person with minor children, how much does not having control over the guardianship of your children bother you? Again, how much does paying taxes on your assets or having your estate pay taxes on your assets, how much does that bother you? And so talking about those things, those are things that we can really talk about with the specifics of your situation in mind. And I hope that you'll reach out to me in a little bit and we can talk about that. Another question that I have, what considerations do we need to make if we're still growing our family? Do we need to redo this after each child? That's a fantastic question. And it's a question that I know is on the minds of a lot of people who have young families and they're not sure that they're done. They're not sure that this is the last child, and they're not sure what the picture is going to look like for the rest of their life and into hopefully their old age when they grow old. And I can tell you, as an estate planning attorney, part of what I do is draft documents that will grow with a family. They still need to be revisited and they still need to be examined and make sure that they're going to do what you want them to do. And it's really important to revisit them often, maybe every 3 years. And that's the reason that I actually offer free reviews every 3 years to go through and to take a look at your documents and make sure that they're still taking care of you in the way that you want them to take care of you. And that includes changes in the law, changes in your family, changes in your assets. Are they serving you and your family the way that you want them to serve you? And if not, then there may need to be some revisions that happen. And those revisions do have a cost, but just know that that it is going to be reviewed. It's something that that will continue to come up, and we'll make sure that those estate plans serve you in the best way possible. Another question that I have here, what interview questions should be asked or what should be considered when trying to select an executor? And that's a fantastic question. Oftentimes, you want to look for somebody who is financially responsible, somebody that you would trust with your money, because that's really what they're going to be doing. A personal representative's job is to collect all of the assets of the decedent, of the person who passed away, to inventory those assets, to look for any debts that that person owed during their lifetime or that they owed at their death, make sure that those people, those creditors that they owed are paid, and then to distribute out the money in the way that you have directed them to distribute out that money. And so that's really what you want to look for a personal representative, for an executor. It's also what you want to look for in a trustee, which is something that we'll talk about in a little bit. Somebody that you trust to make those financial decisions the way that you would want them to be made. And somebody who's, being organized wouldn't hurt either, because there's a lot of organization required in doing a probate or in doing a trust administration. The reality is, these are all fantastic questions, but estate planning isn't really about us here tonight, right? It's about the people that we love, and that's who we're really doing it for. And those three kids on the screen are the reason that I have a completed estate plan. That's Margaret, Ben, and Elizabeth, and they're my kids. And Margaret is 4 now. She wasn't 4 in that picture. Ben is 9, and Elizabeth is 6. And they're really my whole life. And my wife and I are never going to enjoy our estate plan. It gives us some peace of mind. It helps us to sleep a little bit better at night, knowing that they're going to be well taken care of. But really, the reason that we did it is for them and to make sure that they're taken care of in the very best possible way, and that our family doesn't have to fight about who's going to get the kids or who's going to get the money or how that money is supposed to be spent on the kids, because all of that has been taken care of. We've left instructions. They know what is supposed to happen. And that is so important, I think, for a lot of us to know that that's taken care of during our lifetime. So here's what we're going to cover today. We're going to talk about planning for incapacity. This is a big part of estate planning, planning for incapacity. We're going to talk about who can make healthcare decisions for you if something happened and you couldn't make those decisions for yourself, what those healthcare decisions would be. We're also going to talk about who can make financial decisions for you, and again, what those decisions can be. We're going to talk about planning for when you pass away. And if you have minor children, in fact, I forgot to pop this up before, but just another poll really quick to find out where people are at in attendance here today, whether they have young kids or grown kids or no kids. But something that's very important if you have minor kids is guardianship, and making sure that those kids have a place to go, that they have somebody that you've designated, that you've nominated to take care of them and raise them until they're ready to take care of themselves. We'll also talk about planning for when you pass away in the context of probate. And we'll talk about the time, cost, and public nature of probate. And I know that we have somebody here from North Carolina. I'm going to specifically be talking about probate in Minnesota because that's where I'm located. I'm in Bloomington, Minnesota. And so I'll be talking about the laws of Minnesota and what would happen here. We'll be talking about estate taxes. We'll be talking about unclaimed property and what that is and how property becomes unclaimed. We'll also be talking about intangible assets, things like your stories and your values and how those can be shared with the people that you love. Before we get too far into that, it looks like there are people all across the demographic gamut, people without kids, people with young kids, people with grown kids. And again, welcome here tonight. I promise this conversation isn't going to only focus on one group. It's really going to cover everybody, and it's going to speak to everybody here this evening. So this is my family. Again, we live in Bloomington, Minnesota. My wife's name is unique. It's not unique. It's Tobin. It's a unique name, Tobin. And my kids, again, are Ben on the right, Margaret in the middle, and Elizabeth on the left. I don't know why I introduced him that way, but that's them. And my family really, again, is my whole world. So I graduated from the University of St. Thomas School of Law back in 2012, near the top of my class. And on the very next day, my first child, Ben, was born. And somebody says, "Beautiful family." Oh, thank you so much. I really like them too. So after graduation, I found a job with a small estate planning and tax preparation law firm. And I fell in love with working with clients and helping them solve problems for their families. But at the same time, I didn't always feel like I was providing the value that my clients really deserved. And so after a little over 3 years, I actually left that law firm. And this is a picture from my last day there. Something that stayed with me was my parents' extremely negative experience with the estate planning attorney who helped my grandmother before she passed away. And in particular, I remember my mom saying, "Someone has to graduate at the bottom of the class." And I'll tell you, this was not said about me. I'm a little defensive whenever I put this up here. It was not said about me. It was said about another estate planning attorney. And to be honest with you, I don't think this estate planning attorney was dense. I don't think that they actually graduated at the bottom of their class. Maybe they did. I don't know. But I think that they were operating under kind of a faulty model, a very traditional, typical model of estate planning that underserves the people who are having their estates planned. I'll talk about that in a little bit, but I just really want to highlight that not every estate planning attorney is the same. And there are some estate planning attorneys that, even though they're well-meaning, may underserve the people that they're serving. I have a question here, or I have another comment here. I'm in my sandwich years and over 50 parent with teenage children and over 75 parents. My husband and I need to plan for our children. I also need to help my mother plan. I think my father has his affairs in order. Thank you so much for sharing that glimpse into your life, and I'll definitely be speaking to the needs that you might be feeling as one of those people in their sandwich years. I like that phrase. So I know not everybody here has minor kids tonight, but I'd like to touch really quickly on guardianship just to make it very clear what I'm talking about there and how important it is to plan for. So there are two types of guardianship. There is short-term guardianship and long-term guardianship. And when you're talking about short-term guardianship, here's what I want you to think about. If you were out on a date and you left the minor kids home with the babysitter and you didn't have a plan in place, you didn't have any legal documents in place, and something happened and you didn't make it home, and the babysitter was increasingly worried, at some point that babysitter is going to call the police to the house. And when they call the police in and they're not able to find where those kids should go, legally, who should take those kids and who should provide care for them, they're not going to leave them with a babysitter, especially if that babysitter is under the age of 18. Probably what's going to happen is Child Protective Services is going to get involved. And your kids may go and live with a foster family or with Child Protective Services for a time until it can really be determined by a court who those kids should go to and who should care for them in the near term and the short term timeline. And I've got to tell you, this is Child Protective Services does the best job that they can, and foster families can be really wonderful individuals, really wonderful people that are willing to take on and care for kids in a really beautiful way. But that's not what I want for my family. That's not what I want for my kids. And I know that's not what I want. I know that my kids would not be best served by going and being with Child Protective Services for any amount of time. And so I've put in place short-term guardianship nominations for my kids so that it's very clear if something happened and for whatever reason they needed somebody to take them for 30 minutes or for a day or for 2 weeks, who that person would be that would take care of them. And that's really important. It's something that's often overlooked in an estate plan for somebody with minor children. Long-term guardianship is kind of the flip side of that. Who is going to take the kids and raise them until they're 18? And who is going to really create an environment where those kids are going to thrive? And if you don't have a plan in place, the truth is that there is a plan for you. And that plan is that a judge is going to decide. It might be a plan that you don't like. It might be Uncle Larry getting the kids. I don't know. Do you want Uncle Larry to have the kids? It's always a question that I ask young people with young kids. And if not, you really need to put a nomination in place. You need to make sure that it's very clear to the judge where you want those kids to go and why you feel like they would be best served with the people that you've chosen. And that's something that you can do. It's something you can do right now. And it's something that you can do affordably. So I hope you get that done. So let's talk about the assets, and let's talk about how people receive from your estate. And the state has an estate plan for you, and that plan is a court process called probate. And what probate is essentially is a lawsuit that you file against yourself with your own money for the benefit of your creditors, for the benefit of the people that you owe money to. And this is true if you have no estate plan in place. A lot of people don't know, but this is actually true if you have a will-based estate plan as well. As long as you own real estate or have assets in excess of $75,000, and again, these are Minnesota specific numbers, but as long as you fall under one of those different criteria, assets in excess of $75,000, or you own a home or you own some sort of real estate, then the plan for you is probate. And if you're doing an online will, you can't avoid probate. An online do-it-yourself will is not going to avoid probate. And if you go in and you talk to an estate planning attorney and they say, I see that you own a $400,000 house. I think probate, or I think a will is going to take care of you. You've got to ask some questions of that estate planning attorney to find out whether they're really serving your best interest and whether they're aware of the process called probate, how expensive it is, and how much time it takes. And really, I think the worst thing about probate is how slow it is. In Minnesota, probate takes a minimum of 6 to 12 months to get through the process. And that's before you can make distributions. That's before you can get money out to the beneficiaries. The truth is, we'd like it to go faster, but we just can't make it go faster. It's built this way. It's built for the benefit of creditors so that they can take their time and in their time come forward and ask to be made whole from the estate. Probate is also very costly. There's attorney's fees and executor's fees, appraiser's fees, court filing fees, all kinds of different fees and costs associated with it. And probate in Minnesota is generally estimated as costing somewhere between 3 to 6% of the gross value of the estate. So you can imagine if all you own is that house worth $400,000 and you have decided where that house is going to go in a will, then probate is already going to cost you somewhere between $12,000 and $24,000. That's just 3 to 6% of the gross value of that home. Even if you don't have $400,000 of equity in that home, probate's still probably going to cost you somewhere between $12,000 to $24,000. That's the gross estate value. That's how we estimate it. And we'll actually have a chance here in just a minute to estimate our own costs of probate. I see somebody saying that quote is a sobering mouthful. And yeah, it really is. That very few people, I think, would want to file a lawsuit against themselves for the benefit of their creditors, but it is very true. Probate's also public. So I'm showing you here the will of Anna Nicole Smith. Maybe you remember her. It's been a little while since she's been talked about anywhere, but wills are totally public. You can go down to the probate court, and I know somebody had the question earlier, how can I get a copy of the will if I think that I'm a beneficiary in that will? And that's how you can get it. You can go down to the probate court. It needs to be filed with the probate court. And so you can request a copy there at the court. And some counties actually have a dedicated probate court. Some just have the regular court system. But you can request a copy right there, and you probably have to pay a little fee, but you can get a copy of that will and find out exactly what it says, what distributions are made, who is listed as the personal representative, if anybody is listed as having special needs, or if anybody is disinherited. All that information is contained in the will. If the will is really the demonstrative document. How to find the probate court. And for that, it really depends on the county. I would search the county name and probate. And the Hennepin County Probate Court, I know, is headquartered in the Hennepin County Government Center. And I don't know, I'm blanking on where some of the other ones are right now, but doing a Google of probate and the county will tell you where that county's probate court, or what court system handles that county's probate. And that's where you find it, is on the county level. And so another thing about having the will be public, having those distribution provisions be public, is that there's also another part of the probate where you have to file an inventory and you have to file a final accounting. And this isn't always true. Sometimes if you're able to go informal, you can avoid filing publicly that inventory, or you can avoid filing publicly that accounting. But generally there's some kind of inventory that has to be made public, either in the petition or somewhere. So predators out there will have an idea of approximately what your estate is worth. They'll also know who is going to receive under your will, under your estate plan. And that's a really, kind of terrifying thought to a lot of us who know people who might be vulnerable to predators, or have minors that we would want to eventually receive, that they might be preyed upon by predators who are getting that information from the public court system. Another thing, minor children will receive assets at 18 and unprotected. And I think we all know some kind of sobering stories about people who received money at too young of an age or came into money somehow at too young of an age and did not make the best use of it. And maybe it kept them from getting educated. Maybe it kept them from excelling in their career, whatever it was. I think a lot of us have those types of questions. I have another question here. So the final accounting is filed with the probate court too. Again, it depends on which system that probate is filed under. If it's a formal probate, then yes, a final accounting will be filed with the court. You should also be able to request that from the personal representative. They should create an accounting. They should create an inventory, and they should create an accounting that they send to you so that you can actually see where the money is gone. They may ask you to sign a waiver of the accounting, and what that waiver is, generally, it's not some sort of bad intent document or anything like that. Usually, it's just the idea is to make the personal representative's life a little bit easier than having to create that accounting. But you should be able to request that from the personal representative or from the executor, and they will give it to you. So now we'll have a chance to actually calculate what our probate estate is. And this kind of blew my mind when I learned it, but you can estimate 5% of a number by moving the comma over one place and dividing the number in half. And so you can see that's how I got estimated probate costs and fees of $42,500 from this $850,000 estate. You can see here, this estate might seem like a lot to you. It might not seem like not very much to you. But you can see here, I have a family home listed, rental property, furniture, automobiles, stocks, bonds, bank accounts, and business interests. And you can see how that adds up to $850,000 in gross value. Again, that isn't necessarily the equity that's in the family home. It's not necessarily the equity that's in the rental property, but whatever the value of the home is kind of how we estimate how much work it's going to take to get that home up to snuff and get it turned around and sold, and what the fees associated with that are likely to be. And so you can see on that $850,000 probate estate, estimated probate costs and fees of about $42,500. An added wrinkle, if you have a life insurance policy or retirement account that is payable to a minor, you've put a beneficiary designation on it, and that beneficiary is not 18 and is not able to receive that money directly, then those assets are also going to have to go through probate. And you can see how all of a sudden it really balloons the cost of probate by having a minor in line to receive. So I have another question here. Are you saying that a beneficiary can ask while the will is in the probate process for a copy of the inventory? And it's possible. There's a time that the inventory actually happens. There is, in Minnesota, I know there is kind of a partial or abbreviated inventory that's created on the initial petition or on the application for probate. And you should be able to get access to that snippet of information, that snippet of inventory information, even if the full inventory has not been filed or has not been prepared yet. But there is a time later on that inventory will be prepared, and you will have access to it at that time. All right, are these expected costs without proper estate planning or regardless of whether estate planning has been done or not? Fantastic question. These are the costs if an improper estate plan has been done, or if there's no estate plan in place, or if you have been trying to plan your estate with a will. That's what these types of costs are. Probate is avoidable, and the costs of probate are avoidable. And that's what I'm going to talk about next, is how you can avoid probate, how you can do it in an absolutely foolproof way. So the only foolproof way to avoid probate is by fully funding a living trust. And what a living trust is it's an agreement, it's a document, it's an agreement written by an attorney that governs what happens to the assets that are put into the trust. It's not a bank account, but it can hold bank accounts. It's not a business, but it can hold business interests. It can hold real estate. And so fully funding a living trust means, number one, you have to have it written. And number two, you have to actually transfer your assets into that trust. And what it looks like is retitling investment accounts, signing new signature cards at the bank. There's a process at every bank for how to put an account into a trust. And you can know a lot of times they'll just ask whoever's been at the bank the longest to come over and to help you out, because they know the process and they can guide you through the process. For real property, you need to execute deeds to actually put those properties into the trust. And that doesn't mean that you have to give up homeowners, your homestead exemption. It doesn't mean that you have to give up that favorable tax treatment or anything like that. It doesn't mean that your mortgage is going to accelerate. I know a lot of people worry about that. None of that is true. You can put your own home into a living trust. And as long as it's a living trust, as long as it's revocable, there's no problem. The government recognizes it and understands that it's close to having it in your own name, but not having it in your own name, where you would still have to have a probate. There are also, for stocks and bonds, you would transfer those certificates into the trust. You would assign personal property into the trust using something like a bill of sale or an assignment of personal property. And then on accounts that are payable at death, things like life insurance, things like retirement accounts, you would change the beneficiary designation so that at some point, at least, they point to the trust. For a married couple, you may still want your spouse to receive your retirement account directly and then have it go into the trust if something happens to your spouse before. But generally, the trust is the final recipient of the retirement account in that case. All right, I'm not seeing any other questions here. Calculate your estate tax. So here we have an opportunity to calculate estate tax. And this is really where I get to give people a lot of good news. Right now on the federal level, there is an estate tax exemption of $11.7 million. And so that means for your first $11,700,000, you owe nothing in federal estate tax. And that exemption is shared with gifts, with the gift tax exemption. But as long as you haven't made huge gifts or have $11.7 million in your estate when you pass away, you will not be subject to the federal estate tax at this time. Things may change. The current administration may change some things. Right now, they're talking about lowering the exemption to $3.5 million. Again, they're also talking about making changes to the step up in basis. And what a step up in basis means is if you own, for example, a rental property, and I'm not using a family home for a reason, there's a different homestead exemption that applies to your homestead. But if you own a rental property, for example, and you've depreciated that rental property over time, maybe you bought it for much less than it's worth right now, there is a capital gain that you have to pay when you transfer that property out of your current name. And so that long-term capital gain right now is a lower amount, but the current administration is talking about increasing that amount to 39.6%. Also right now, if that asset is subject to estate tax, it would not be subject to capital gains tax. But again, this is something that the administration is talking about changing. And so they're talking about changing the way that the step up in basis happens. So only the first $1 million in assets, which I know is still a lot to a lot of us, but only the first $1 million would receive that step up in basis. And so that means that you could be subject to estate tax. You could also be subject to capital gains tax, income tax on that property, or your heirs or beneficiaries could be subject to capital gains tax on that property when it transfers to them, instead of receiving the value of the property when the person passed away. So I've talked about that a lot, and I know that's a lot of detail, and there might be some questions here. So I'm just going to see. This may be outside the scope of the presentation. Can someone have a trust and receive Medicaid? And the answer to that question is yes, but it really depends, and it's really going to be specific to the questions of your situation and how things are working. So a revocable trust is treated as if you still own the property for the purposes of Medicaid. And so the asset test is going to be applied against those assets to determine whether or not you qualify for Medicaid. There is some planning that can be done in order to qualify for Medicaid while, when you initially had assets that would not have allowed you to qualify for Medicaid. If that's a concern for you, If you are worried about the cost of long-term care or you're worried about the cost of nursing home care, I completely understand. It is very expensive right now. And the state's plan to have you spend yourself into poverty is really distressing to a lot of people. And so if that's a concern that you have, you can talk to me and we can talk about your specific situation and how we can resolve that. Another question here is, if a property is transferred to a living trust, the step up in basis is lost, correct? That is not true. You still can receive the step up in basis if the asset is transferred to a living trust. If the asset is transferred to an irrevocable trust, one that you cannot revoke and that has some special treatment and some special creditor protections, then you do lose the step up in basis in that case. And that might be your experience with it. That might be where you're getting your understanding of losing the step up in basis again. Please explain step up in basis again. And I wish that I had a slide for this. I just recently did a presentation on step up in basis. And so let me try and explain it again. You have, in this example here, there's a rental property worth $250,000. But if you own rental property, you know that you've probably depreciated that rental property over time to a point where it doesn't have a lot of the initial equity that you put into it. So let's say that you bought that rental property for $100,000. Now it's worth $250,000, and you've applied $50,000 worth of depreciation to that asset over time. So now the rental property has a basis of $50,000, but it has a worth of $250,000. And so if you sold that asset, if you got a realtor and sold it on the open market, you would receive $250,000, but you would owe tax on the difference between the fair market value and the basis in the property. And so you would owe tax on $200,000. And right now, long-term capital gains tax, I believe, is 20%. Don't quote me on that. This is not tax advice, but I believe it's something like that. And so $200,000 times 20%, you would owe about $40,000 in tax on the sale of that rental property that you were able to sell for $250,000. And so you would have to pay that to the IRS. You may owe other capital gains tax that may apply you to a higher marginal rate for some other sales that you have, sales of stock and that sort of thing. So it can have kind of a ripple effect through your income taxes. But that's what basis is usually the amount that you bought a property for, or if depreciation applies, the amount that you've depreciated that property down to. And so in the past, for hundreds of years, or for over 100 years, we have had a process where if property would be subject to estate taxes, if it makes up your estate taxable estate, then you receive a step up in basis. And so your kids, when they inherit that rental property, would not inherit a rental property worth $250,000, but with only $50,000 in basis. They would actually receive a rental property worth $250,000 and with a basis of $250,000. So when they sold that rental property, they would owe nothing in capital gains. The value of the property is the same as the basis of the property of what it's treated as is being purchased for. So that's what step up in basis is. And that's currently under review by the administration. And they've looked at limiting that amount of step up in basis to $1 million so that anything above $1 million is taxed at a capital gains rate that they've talked about setting at 39.6%. So it's really a pecuniary rate. It's really a high rate that is aimed at stopping windfall to beneficiaries or to people who are selling things that have long-term gain in them. So hopefully I've explained that. If you need more clarification on that, please feel free to ask me, but I might talk about it more at the end. So I have a question here. If you make a trust, but don't put all the assets into the trust accidentally or otherwise, can you still end up with 1 foot in the probate world? 100%. Yes. And it is a big problem. It's a big problem with the typical estate planning model is that a typical estate planning attorney does not build in the time and attention that is really required to make sure that the client is fully funding their living trust. And that's something that's very different about working with me. Working with me, I make sure that you get your trust fully funded. And I do that through follow-up with you, or I also have some availability where you can work with me to actually have me take on the funding of your trust. And that's a possibility as well. So that's a really insightful question, and I'm glad that you asked it. It is very important to fully fund your living trust, because a failure to do so could end up with you in probate, which is exactly what you don't want. Any idea how much money is in our State Department of Unclaimed Property right now? Over $700 million. And a big part of the way that that money gets into the Minnesota Department of Unclaimed Property is that somebody passes away and their family didn't know all of the assets that they owned. They weren't aware of some bank account somewhere or some stock that was owned, whatever it is, and it ends up in the Minnesota Department of Unclaimed Property or a Department of Unclaimed Property across the United States. Across the United States right now, there's over $58 billion in the states of the state departments of unclaimed property across the United States. It is a crazy amount. And I can tell you, as a father of three, as somebody who is still building their estate, whose estate is not worth an estate taxable amount at this time, but is working on it and is building it, I can tell you, I want every dollar of my estate to go to my kids and to be used for their care and to make sure that it takes care of them, that it doesn't end up in the state, it doesn't end up lost. Even if I have, electronic statements turned on or whatever the case is, I want that asset to be found and I want it to get to the people that I want to receive it. I have another question here. In what states are you licensed to serve? And I am licensed to serve in Minnesota, but I have helped people in other states through the use of co-counsel. And working with me, you're probably getting a feel for my personality. I try to be fun to work with. I'm certainly earnest and honest with people and transparent. And so a lot of people want to work with me. They know I'm going to take very good care of them, but I'm not licensed in their state. And so what I do is I work with an attorney in their state to make sure that they're able to work with me, and that we're able to get an estate plan written within the guidelines of their state, within the laws, statutes, and rules of their state, to make sure that they're getting the very best treatment possible under the laws of their state. And so again, I just co-counsel with an attorney who is an expert in that state, and I'm able to help people in other states that way. Everybody in Minnesota is very lucky because I can work directly with them, and we don't need to have that intermediary, that co-counsel, but that is where I'm licensed, is here in Minnesota. This is really cool. And this is something that is kind of new, but there is a way to build asset protection into your living trust in a way that it protects the inheritance that you give to the people that you want to receive. So that inheritance can be protected from things like divorce. It can be protected from things like a lawsuit in the future, or something like a car accident in the future for your beneficiary. It is possible to build in this asset protection by including something called a lifetime asset protection trust. And if that's something that sounds kind of interesting to you, if you've heard stories of somebody who has lost a lot of their assets or a lot of what they had to something like a divorce, it might be something that's on your mind, that you want your kids to receive an inheritance, but you're concerned about a spouse, or you're concerned about who they might choose as a spouse down the road, and whether that person could receive half of the inheritance that you want them to receive. What if you have a state in a few states but reside in one state? Should attorneys in all states where you have property be involved? And that is a very fantastic question. Really, the primary attorney that you're going to work with on an estate plan needs to co-counsel with somebody who is in the state where you are principally domiciled. And so that means either 6 months plus 1 day, or if you have more states that you are spending time in, then it might mean the state that you spend the majority or the most amount of time in, if that's the case. But that is a really good question. You also probably want to have co-counsel involved in recording property in the other states as well. If you own real estate in multiple states, you're probably going to need to engage either a title company or an attorney who can handle a real estate transfer in that state. So this is something that's really real for people. This slide is really something that's really real for people right now in the midst of COVID-19. You might recognize the person on the screen. It's kind of a terrible picture, but this is a picture of Terry Schiavo. And for those of us who are a little bit older, we remember Terry Schiavo as somebody who it wasn't clear how much Terry Schiavo was a part of our world anymore. And her parents had the idea that they wanted Terry to continue to receive nutrition, that they wanted her to continue receiving hydration. And if there was any chance of Terry experiencing our world or coming out of the vegetative state that she was in, that they wanted her to have the possibility of having that happen. On the other hand, her husband felt that he knew Terry's wishes the best and felt that she wouldn't want to live in that vegetative state, that it was not a form of living that had enough value to Terry. And so he wanted her hydration and nutrition stopped. And this case really sent shockwaves across the entire United States. There were court cases in Florida, there were court cases in the Supreme Court trying to decide what Terry's fate would be. And it was really created a lot of court and a lot of conflict for everybody involved and really for everybody across the United States. But that doesn't have to be the case. Terry could have put in place a healthcare directive that not only named who she wanted to make healthcare decisions for her, but also named what those healthcare decisions would be. And that could have provided a lot of clarity to the people in her family, and it could have provided clarity that could have avoided the conflict and could have avoided the court that ended up happening. So that leads us here. What can you do today to do the right thing for your family? And what should it cost to plan right? And really your options, if you don't like what you've heard so far, if there's something that has kind of stuck in your craw, either probate or maybe you think you might be subject to estate tax and you want to get something done. Maybe you're worried about losing assets to unclaimed property. You're worried about guardianship for your kids, or you're worried about incapacity and who can make financial decisions for you or healthcare decisions for you. You really have a couple of choices. You can do it yourself, or you can work with a lawyer. And do keep in mind that not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer? And I can tell you, if you own more than just your personal belongings, the things on your back, things like your car, clothing, jewelry, furnishings, those types of things, then you would probably benefit from working with an attorney. If you own a home, for sure, you would benefit from working with an attorney because you really, at that point, probably want to avoid probate. You want to avoid that expensive probate and also the time and difficulty that it really causes. If you want to ensure that the people that you love stay out of court and conflict and have someone to turn to when something happens to you, then you really want to work with an attorney. You want to have somebody who can be a trusted person that they can turn to and who can provide guidance. If you want a kids protection plan, which includes not just that long-term guardianship that most estate planning attorneys do, but also a short-term guardianship nomination. And if you want to avoid probate or estate taxes, or you want to protect your children's inheritance from things like divorce and things like lawsuits, then you have to work with an attorney. Those are things that an attorney has to be involved in order to help you with. If you want to guarantee that your plan is going to work for you when your family really needs it, then you need to work with an attorney. And this was something, it was actually over a year ago now, but I was putting fishing line on my son's reel as we were preparing to go fishing for the first time last year. And whatever I did it wrong. And so I think I wound the reel the wrong way. I don't even know how I did that. I don't know what I did, but all of a sudden the line started jumping off of the reel. And I sat there and I watched it happen, and it was a bummer, but guess what? It happened right there in front of me. and I saw it happen, and I was able to pick up that reel and start again. And I was able to rewind the reel, try and say that 5 times fast. And I was able to get it to a point where I could go fishing with my son, and there wasn't a lot of damage. There was some lost fishing line, but it wasn't a big deal. That was a do-it-yourself project that turned out okay. It was a do-it-yourself project that failed at first, but guess what? I was able to get it right and to get it fixed. But estate planning is not like that. If you do it yourself for an estate plan and it doesn't work, you aren't going to be there to fix that problem. You aren't going to be there to redraft those documents or reword them in ways that you wish you would have worded them when you did it the first time. You're not going to know what's happening, and your family might be suffering through court and conflict. People might be receiving assets that you wouldn't want receiving assets, or not receiving assets that you would want them to have. Your kids, if you have minor kids, and I hate being a fear-mongering type of person, but this is just so important. It's just so vital that you get it right. Doing it yourself does not leave room for error. And I hate to see the number of people that I've had come into my office or conference with me and tell me that they tried to do it themselves, and or their loved one tried to do it themselves, and now they're very afraid of what the future holds. It's not a good scene. And so if you really want to guarantee, if you want to know that the plan you're going to be working on is going to work for the people that you need it to work for, then I really encourage you to work with an attorney who is going to be able to help you with that. And if you want to give your assets to someone other than your kids, if you want them to go to someone other than who they would naturally fall to, then you really want to work with an attorney and make sure that you get that language right. Whether it's a charity or whether it's just a different person that would normally receive, you really want to make sure that the language is very clearly written so that other people don't have a claim against it. I have a few questions here, but I'm going to push on just a little bit and address those questions at the end, because they're very good questions. I want to revisit this quote now. This quote that my mom said, someone has to graduate at the bottom of the class, about that estate planning attorney who really underserved my grandmother and really underserved my grandmother's family, who had to clean up the pieces. And again, I don't think that attorney probably graduated at the bottom of their class. I think they were just trying to do estate planning in a way that they had learned 30 years ago or something. And it was a way that didn't help my family. It was a way that underserved my family and caused them to have to go through some conflict that they never should have had to go through. This is what that traditional or that typical experience really looks like. Typical experience, you're going to work on some documents. Really, the lawyer is going to kind of size you up when you come into the room. They're going to have some recommendations probably already written out for you about what those documents are going to be. They're not going to educate you about the estate plan that they intend to put in place for you. They're not going to empower you to make decisions surrounding that estate plan. They might let you, decide who you want to receive or who you want to serve in certain different roles, because generally they do that. But generally, they're just going to kind of size you up and write an estate plan that they think you're going to want. And you're going to take those documents, you'll probably put them on a shelf. You won't look at them again. You won't update them when there are changes in the law or when there are changes in your family or in your assets. And you're not going to want to call the lawyer, because every time that you call the lawyer, they're going to charge an hourly fee again. And that sends a really clear message when you receive that bill in the mail 2 weeks later that your attorney doesn't want to talk to you unless you're paying them some money. And again, one thing that we talked about before, one question that I had that came in that was so fantastic: if a trust isn't fully funded, then you aren't fully protected, or your family is not fully protected. If a trust isn't fully funded, you could end up in probate for whatever assets are not in the trust. And that is so important. It's something that a typical estate planning attorney isn't going to take the time to do. It isn't going to take the time to make sure that you have it really clear and really taken care of. And so you can see here, I'm not going to read through all the bullet points because you can read through them. But I just want you to know that not all attorneys are the same, and I do things in a very different way. And so this is really a picture of how I do things a different way. I work from flat fees, and you can actually choose your own fee. And that doesn't mean that I'm just going to rely on your benevolence to tell me what you want to pay me. It's not a donation, but I have different fee packages, and we'll talk about exactly what's included in those fee packages, and we'll talk about what's going to serve your family in the way that you want them served, and what's worth it to you, and what's not worth it, based on what those packages cost. Working with me means you can keep your money out of the hands of the state. You can protect your kids totally. If you have minor kids, you can protect them for the short term and for the long term. You can keep your family out of court and conflict. And really, I'm a peacemaker. This is the thing that matters the most to me, is that I'm able to help my clients avoid court and conflict in their family and really take care of them, and really to provide a plan that's going to take care of the people that they love when they can't be there to take care of them. You're going to know that you've made the right decisions because we're going to make those decisions together. I'm going to empower you to make those decisions. I'm not going to make them for you. I'm going to be there to educate you so that you really understand your plan after we've worked on it together. It's not a mystery to you. It's all clear, and you've chosen what you've chosen. I can also help you protect the family money from outsiders, from things like divorce, from things like lawsuits. And you can see I'm young. I'm not as young as I look, to be honest with you, but I'm young. And what that means for you and what that means for your family is that I can be here to provide a lifetime of guidance and protection for them, because I'm not going anywhere. This is the area that I'd love to serve people in. It's the area I'm going to be in here. And the biggest thing is that you know that your plan is going to work when your family needs it. It's really a gift that you're giving to the people that you love. So I promise you that I would talk about this. I promise that I would talk about the costs of getting an estate plan done, because I know that this is something that a lot of people are concerned about. I know a lot of you shared that this was really the thing that was holding you up, was estate planning was too expensive. But I want to highlight again that we live in a society now, we live in a world with word processors, and we can make this affordable. I've been able to make estate planning affordable for everybody. I have never turned anyone away because they couldn't pay the fee right then and there. They couldn't make it work somehow. I work with families, and I make sure that we can really protect them in a way that's going to serve their families when they can't be there with them, in a way that in a way that is mutually beneficial to everybody involved. So what should this cost? If all you have is a home that's worth $400,000, and I know some of you might say that's a pretty nice house. Some of you might say, where are you buying houses worth only $400,000 with the crazy real estate market the way that it is right now? But this is just an average. This is just an estimate. If all you have is a home worth $400,000, 3% of the value of that home is $12,000. So you can expect the probate would probably be something like $12,000 on that $400,000 home. If you have assets over $3 million, then this planning is going to save your family at least 13 cents on the dollar for everything over $3 million. And that's the estate tax in Minnesota. There's an estate tax exemption of $3 million with a 13% estate tax rate once you get above that $3 million number. The typical plan, the typical traditional plan that I was telling you about, would be at least $1,500. If you're finding an estate planning attorney that is charging something less than $1,500, there's something fishy about the way that they are doing things. But that's what the typical estate plan is going to cost. And it's gonna, more often than not, let you down. They're not going to be able to take the time to help make sure that you get your trust fully funded, if they're even writing you a trust at all. I know there are a lot of attorneys out there who they don't have the time to help fully fund a trust, and they get frustrated with it. And so they just start writing will-based plans and telling people, you're going to have to go through probate. I'm sorry, but trusts don't work for me. I haven't been able to make trusts work. And they generalize it to the entire industry that trusts don't work. And it's not true. Trusts can work, but you need to work with an attorney who will devote the care and attention to make sure that that trust really works for the people that you need it to work for when you need it to work for them. That typical estate planning attorney isn't going to create an inventory. They're not going to do anything to protect your assets from the State Department of Unclaimed Property. So things might get lost in transit or in transfer at the end of your life. It's only going to cover your money. It's not going to cover kids' immediate care, their short-term guardianship. It's not going to cover your values, insights, stories, and experience. And all this is really true of a do-it-yourself online will type plan. It's not going to take care to avoid probate. It's not going to really help you. I was talking to a friend the other day, and he writes estate plans as well. And he said, I've heard it described before that trying to do it yourself with an estate plan is like putting IKEA furniture together without the instructions. And it really is that complicated. There are a lot of different moving pieces, and it takes a lot of attention and care, even when you've been doing this as long as I have, to make sure that things are done in the right way to really protect the people that you love. So here I'm going to tell you, my plans cost somewhere between $2,000 and $8,000. And where you fall in that range is up to you. You're going to choose where you fall in that range based on the protection that you want to provide to your family and based on the different things that you think are important to your family. I'll help to guide you in that decision. We'll talk through all of the different options and look at them together. We'll talk through everything that's included, everything that's not included in different packages. But you can know at the end of our conversation, you'll know exactly what you're going to pay for that plan that is going to take care of your family and is going to keep them out of court and conflict, and that is really going to show them your love when you can't be there with them. So let me make this easy for you. Right now, I want to give you two gifts. And that first gift is a $750 family wealth planning session for absolutely free. And I see a question coming in right now. Do you offer a free consultation? The answer is absolutely yes. That's the family wealth planning session. It is a 2-hour-long working session where we will talk about the state's plan for you. We'll talk about the people that you love. We'll talk about everything that you have. We'll talk about exactly what is going to happen when you either become incapacitated or when you pass away. And we'll talk about how we can change that plan, how we can change the state's plan, how we can change your current estate plan to more closely match what it is that you want for your family, what it is that you want for the people that you love. And I'm going to go ahead and share this link right now because this is my booking link. And you can see there, I have times available to meet with people for that family wealth planning session. That session, again, that I want to give you for absolutely free, no charge, because I want you to come in and have that conversation with me. I want to know the specifics, and I want to share with you exactly what is going to happen in your specific circumstances so that you can know what your family is going to be looking at when you can't be there to help them through it and to take care of them. That's why I offer that for free. There's no obligation. If you end up walking away from that meeting saying, I'm really good with my family going through probate, or now I know I don't own enough assets where I would be subject to probate, my estate would be subject to probate, and I'm not worried about the other things, then that's okay. I will feel really good to know that I've empowered you, that I've educated you, and that you feel comfortable with the state's plan for you or your current estate plan if you have an estate plan in place right now. But if there are some changes that you want to make, then I want to give you another gift as well. And that gift is $250 off the estate planning fees, the estate planning package of your choice. And again, that package is likely to be somewhere between $2,000 and $8,000. Those are where my packages are, $2,000 to $8,000. I want to give you $250 towards the package, again, that you choose, that you know is going to serve your family in the best way possible. And I don't know if everybody has clicked through yet to get to my booking link, but when you do, you're going to see there are very limited times here in June that are available. And the reason for that is I really focus on serving a few clients at a time. I focus on serving a limited number of clients at a time because I know the amount of service that it requires to really make this work, to make the estate plan work for them and to work for their family when they really need it the most. And if I start serving too many clients, the way that I know a lot of estate planning attorneys have to practice when they're charging lower fees, they start trying to serve too many people, and that's where they start to get into trouble. And I have news. It's unfortunately not malpractice. It is common practice. What is happening out there in estate planning, where people are being underserved, and unfortunately, it ends up leading to probate. And there is that. So I am going to go ahead and answer some questions here. But again, I just want you to take those next steps. Click through to the link, take a look, see if any of those times that I'm offering work for you. And I understand, not everybody can make the decision right here and now. I know people have significant others that they need to talk to about this, that they need to confer with. And I really encourage you to do that. I want you and your significant other to join me for that family wealth planning session, because it's likely that they're going to have questions that you don't have, and it's likely you're going to have questions that they don't have. And so it's really important that you're both present for that free family wealth planning session, and that you both come to it with a mind to learn, to be educated, and to be empowered, and to be able to make decisions about the future of your family in that meeting. And again, use that $250 towards the plan of your choice if you do choose to go on and complete a plan with me, which I really hope that you do. Most people do. Most people come in and meet with me, and when they see the things that would happen, when they see what it would look like for their family when they pass away, most people do choose to take advantage of that $250 savings and create a plan of their choice. So again, I have a ton of questions here. I'm going to start taking them. What is pre-work? I assume that is a reference to the homework for the family wealth planning session. And this is work that you're going to do ahead of time. It's some information that you're going to collect about your assets, about your family. And I can tell you, it is going to make you more organized about your finances than you have probably been in a really long time. But it's work. It's some work that you have to do in order to make our meeting really efficient and to make it the clearest picture of where your family is going to be when something eventually happens to you. So that's the pre-work that needs to be done. It's a form. It's an online form that you fill out. And I've tried to make it as painless as possible. It is painless, I promise, but it does require some work to fill out. But I'll tell you, you are going to come out of it feeling so financially organized. It's something that I do from time to time to really create an inventory and update an inventory for my family to make sure that they're well taken care of. Great. Somebody said that they just scheduled an appointment in July. Will I send the pre-work paperwork prior? Yes, I will. And you'll see that in your email soon. I really appreciate you booking a meeting, and I'm excited to meet with you. I have somebody asking, can we choose a guardian for our kids from another country? And I'm sorry that I haven't gotten to your question until now. It's almost 20 minutes since you've asked your question, but I'm going to answer it now. Yes, you can choose guardians for your kids from another country. If you're choosing guardians for kids from another country, if your guardian is from another country, it is so important that you have that short-term guardianship in place so that somebody has the legal right to stay with the kids. There's even more that I would really recommend that you have in place. Things like a medical power of attorney or a healthcare directive for those kids so that somebody can make those healthcare decisions for them. If an emergency comes up and they end up in the emergency room, somebody can take care of them and make sure that they are going to be taken care of with the best healthcare decisions, the healthcare decisions that you would make for them, really, which is so key. I have another question here. Can you again, please tell the main difference between revocable living trust and irrevocable living trust? So again, revocable living trust is going to be revocable. You can amend it, you can change it. And the reason for that is that there are three roles, three different parties to a trust. There's the person creating the trust. I should do this. There's the person creating the trust. There's the person who has control in the trust. And then there's the person who has the ability to benefit from the trust. And in a revocable trust, you maintain all three of those roles. You're the person who's creating the trust. You're also the person who has all of the control, including the control to completely revoke the trust. If one day you wake up and you say, these kids are driving me crazy. You know what I'm going to do? I'm going to send them to probate. I revoke my trust. And you write a document that says, I revoke my trust. You have the power to do that. As the trustee, you have the power to do that. And so as the creator as well, that's a power that's reserved to you as the creator of the trust. But you're also the trustee, which means that you have all the ability to control and interact with the trust. And then you're also the beneficiary, that during your lifetime, you have all the right to benefit from your trust. It's your assets that you put into that trust. And so you should maintain that ability to benefit from the trust, which is so important. Another question: is a fully funded estate plan paid for like a life insurance policy? I'm sorry. I meant to say, you contrast that revocable trust with an irrevocable trust where you give up one of those roles, at least one of those roles. Generally, you give up the trustee role where you have control over the trust. So you can no longer revoke it. You can no longer amend it or change what it says. And there are even ways to get around that. But that's really the key. That's really what it means is you start giving up some of that control. And you also may give up your ability to benefit from that trust. So those are the main things that you give up in an irrevocable trust that you would maintain in a revocable trust. Is a fully funded estate plan paid for like a life insurance policy? And I'm not exactly sure if that means paid for like a life insurance policy, if that means that it's paid for over time in premiums, or if that means, I'm not exactly sure what that means. So if you could clarify that question, I would really appreciate it, because I'd love to answer that for you. Thank you again for this webinar. It was very clear and insightful. I really appreciate that. And I really appreciate you being here. I appreciate everybody being here tonight. Will a link to this recording be made available to all attendees so we can watch it again? Will a transcript of the questions be included? Oh, that's a great question. I have not traditionally included a transcript of the questions. Let me look into that and see what I can do about that. But a recording absolutely will be included, will be sent out to everybody. Okay, so it looks like asking about the life insurance, the fully funded trust, and how a fully funded trust is paid for. Somebody saying that's what I'm asking about is payments. And maybe you're asking for payments after the person passes away. And so the trust is really going to detail how those payments are made out. But it looks like you're talking about premiums. So how do you pay for a trust? And a trust is an agreement that an attorney is going to write. And so it's kind of a transactional experience, but really I like to think of it as a relational experience. My clients come in and they tell me what kind of trust they want written. They tell me what they want to have written into that trust. I provide guidance, and my knowledge of Minnesota law and of the different things that a trust can do and a trust can't do, the things that a trust has to do, and the things that you really want to make sure that you include in a trust, because it's going to get you the best treatment possible. So we talk about all of those things, and you pay the fee for me to write that trust for you, and really to write a whole encompassing estate plan that's really going to take care of everything from incapacity to death to your insights and values as well. So that's how you pay for that, is by paying to work with me in that fixed fee, those flat fee packages that I've talked about. A trust is an option in there. Why would people even set up an irrevocable trust if they give up some controls of it? That's a great question. There are a lot of reasons to do irrevocable trust. One of those reasons is if you have concerns about estate taxes, you can create an irrevocable trust where you don't have control over the provisions of that trust anymore, but you're able to purchase a life insurance policy with that trust, and then it is not subject to estate tax when you pass away. So that's one reason that you create an irrevocable trust. Medicaid planning is also another reason that you might create an irrevocable trust, because certain Medicaid planning can be done if you give up control of your assets by putting them into that kind of irrevocable trust. Right here, I just scheduled an appointment. Okay, good. Yeah, I read that one. Why would anyone want an irrevocable trust? Good question again. Thank you for this webinar, Timothy. Very informative and a prompt to action. I enjoyed it. Oh, thank you so much. I really appreciate that. I apologize for my question not being clear. No, don't worry about that. I was asking whether a fully funded estate plan was paid for through monthly premiums. You've answered the question indicating you have a flat fee. Perfect. Okay, good. No, do not apologize for that. I want to be clear. And if I'm not being clear with my response to your question, I'm glad that you reemphasize that. Do I help people from Iowa is another question that I have coming in. And I have worked with people in other states. I'm trying to think if I have worked with any Iowans at this point. I don't think so, but I have helped people who own property in Iowa, Minnesotans who own property in Iowa. And so I've helped them to make sure that they have fully funded that property into their trust. And I, again, would be happy to work with co-counsel in order to help somebody in Iowa to get an estate plan in place that is going to really protect them, that is really going to serve them in the best way possible. And so I would be happy to help if I can be of service to you, again, through the use of something like co-counsel, which is really to protect you, which is really to make sure that you get the very best treatment under Iowa law. Can we send you follow-up questions? If yes, what's your email? Let me put that right here in the chat. That's my email address, and that TJS Law Office is my email, or is my website as well. I post blog articles there, so you may find the answer to your question in those blog articles, but I'm also happy to take those types of follow-up questions there. You may have also seen on my booking link that I have availability to do 15-minute free phone consultations. And if you are not ready right now to sign up for a full family wealth planning session, and you just want to have a little bit more of a talk with me, or you have some questions that you just want to bring to a 15-minute phone conversation and see what my responses might be before you book a family wealth planning session, you should feel free to sign up for one of those 15-minute phone consultations. I'd be very happy to speak with anybody who's attended here tonight. Thank you for hosting this webinar. You answered a lot of questions, and a lot of questions were raised I didn't know I need to consider. Absolutely, that's why I'm here. I love educating people. I'm really a peacemaker and an educator at heart. And again, thank you for joining me, and thank you for giving me your attention tonight. Do all pieces have to be done at once? Could we set up a guardianship as soon as possible while we work on the trust? Absolutely. We can figure out a way to make this work. Just reach out to me. Let's figure out something that works so that you can make sure that your kids are protected. Make sure that they're protected in the immediate term, that they don't have to go and be with Child Protective Services, but also so that a nomination is in place so that the person that you want is going to be raising that child until they're 18, and they're going to be in an environment where they are really going to thrive. That's definitely something that we can talk about and figure out a way that we can make things work for budget purposes or for time purposes, whatever really is motivating that question. We'll figure out a way to make it work. Is the 2-hour family planning session free? I just want to confirm. Yes, it is a free session. I valued it at $750 because it's 2 hours of my time plus some prep time. Really, its value is probably higher than that because I charge an attorney's hourly fee, but I don't charge that hourly fee generally. I just have an hourly fee for, whatever. The point is that it has a very high value because it is taking my time, and you'll have access to my time, my expertise, and really all of my attention for those 2 hours. But I want you to have it for free because I think it is so important to get educated. It's so important to get clear and to be empowered around this topic. And again, it's completely free. It is no obligation. But I want you to book that meeting, and I want you to come into that meeting with me really prepared and really ready to talk about things for me to serve you in that way. I'm going to go ahead and post my link just one more time and look here and see if I have any other questions. I know in the past I've had questions about supplemental needs trusts and whether that's something that I work on. If you have someone with special needs, if you have somebody in your life who you are hoping to take care of after you're gone, it is so important to talk to an estate planning attorney and make sure that you have something like a supplemental needs trust or a special needs trust. Have all the appointments been taken? I'm not able to select a time slot. You may need to go into the next month. It's possible that I've booked up completely for June, and I can take a look here. Looks like there's a spot in June still. Looks like some of the slots in July have been grabbed so far. Did you, when you click on my scheduling link, did you click on family wealth planning session? Because there is a second thing that you have to click on there, and then you should be able to see some time slots still available there. But to go back to that question that I often receive, if you have somebody with special needs in your life, it is very important to get that planning done to make sure that they don't get disqualified from receiving government benefits. What do I recommend for 18-year-olds? So some of us may have kids who are going to college for the first time, or maybe they're going back to college, or maybe they've just graduated college. And I really recommend getting a power of attorney done, a healthcare directive done. Those are really important things to have in place for an 18-year-old. Because guess what? An 18-year-old is no longer a minor. And so their parents no longer necessarily get access to all their healthcare information. They don't necessarily get the ability to make healthcare decisions for that no longer minor person, for that now new adult. So that's really important. Also, again, if you have concerns about nursing home care, I know that's something that a lot of people have concerns about. It is something that I can help you with, and it is something that that we can take a look at different ways to avoid that expense of nursing home care. It looks like I have quite a few people who have already booked appointments with me. I hope that if you are still on the line here, that you've been able to find a time that works for you. If not, feel free to reach out to me, and we can see what else we can do to make sure that you have a time where you can meet with me. Having said that, I'm going to sign off here. It has been really fantastic having you join me tonight, and I hope that this has been educational for you. I hope that you feel empowered through this webinar and that you have a good understanding of where you need to go from here. I'm available. I'm a resource for you, and I want to be available for you to make sure that you're taking care of your family in the best way possible. So feel free to reach out to me at any time. Email me your questions, schedule a phone call. I'd love to talk with you, and I hope that you have a great rest of your night. Take care.